And may I be permitted? Respect of item. Can they five? All are identical item matter. Kindly I am making upgradation with the extreme urgency.
Hearing. We have already started taking up hearing. Thursday we had taken up all the hearing matters. Again Thursday they will be taken up. Don't worry. Yes.
I mentioned for reconstruction, your lordship direct me to come back on Monday so that I can.
Huh?
Your lordship last question direct me to come back on Monday for reconstruction. This is double pasted to 210 lordship. File could not be found before the Monday once your lordship called for report they have filed. Oh, this is 2 month lordship. To make it tomorrow to be mentioned so that I can reconstruction.
What is it? A review?
Lordship. This was the similar matter.
You give the slip.
Can I make it tomorrow to be mentioned so I can bring the all entire
You give the slip. Let us see.
after 2 months lordship.
Lordship, may I mention a matter?
Hearing. Nobody appeared. We called the hearing matters on Thursday. We had fixed. Again on Thursday they will come. Yes. What did the hearing starts at which serial? The hearing list starts from which serial number? The hearing list starts from which serial number? 208. We had called 50 cases on Thursday. Nobody was here. Again on Thursday it will come. You be here. We are fixing a date. Why one hearing should be taken out? We are taking up the hearing matters on Thursday.
It is a matter 2013 hearing matter.
Hmm?
2013 hearing matter. I have served the affidavit.
2013
hearing matter. I have served the.
Just now we have said we are taking up hearing matters on Thursday. You be here. Yes. Slip is not required. It's already in the list.
No, it is not
For
in
inclusion.
the list. It is
Oh,
for after-
give. It will be included. Give.
For inclusion in the list.
Every hearing we have to repeat the same thing. You are listening, still you are mentioning. Yes.
In respect of item number 4 of your lordship list today, my lord, I
4. Yes.
have indicated your lordship, my lord, due to personal difficulty today, your lordship kindly make it not today. My learned friend is here, my lord. Your lordship, just-
Not today.
or not this week, that battle for my personal difficulty, lordship. If you
All
lordship,
right.
so kind, lordship.
You are for?
I am for the respondent. My learned friend is appearing for the appellant.
As prayed by learned counsel for the respondent, matter is adjourned 1 week.
1 week. So, good. 4.
My lord, may I be permitted to mention one matter? My lord, this is a matter where your lordships, 4 matters were filed by the writ petitioners and 4 matters were filed by the ESI corporation. Now your lordships has been pleased to pass the order judgment. Now my lord, it requires some correction. My lord,
Give.
may I be?
Who is
I
here
shall-
to give?
Yes, my lord, I shall go to the court and I shall hand over the
Yes,
slip, my lord.
give the slip. There are 8 matters.
Yeah, there are 8 matters, my lord.
Yes. All right. You
Grateful, my
select.
lord. I shall go to the court and hand it over, my lord.
Yes.
Grateful, my lord.
To
Much
be
obliged.
mentioned for correction. Some correction is there to be mentioned Wednesday.
My lord, may I permitted to mention, my lord, one matter for inclusion, my lord.
Give.
Extremely grateful, my lord.
No, my lord. Item number 1.
Item number 1,
What is the mistake?
The only correction will was written as 46 years, it will be 57. Page 2, paragraph 6, third line.
Page 2,
Paragraph 6, third line. 3, 7 and 8 are 53, 46 and 46.
47,
Now, this will be 57 and 57.
53, 57 and 57.
Yes.
Yes, there is a inadvertent typographical error pointed out by the learned advocate appearing for the petitioner. Stop. The age mentioned in the third line of paragraph 6 as 53, 46 and 46 ought to have been 53, they should. It is always better that the matter is settled by the apex court. Whatever has to be either this way or that way, it is better. Please.
Instruction 3-4 matters, similar type of matters.
Already filed.
Already no. Files have been sent. For
No, it is better since once we have, then uniformly everything can be done. That is better.
My hands are very good.
All right, everybody has their own story. According to them, they are overage. According to you, you are poor. Let us. Yes.
Item number 2.
Lordship, I mentioned, Lordship, I served notice, but I showing one thing, Lordship, this Lordship conversation with me, Lordship, has been loaded in the YouTube. If Lordship shows, I will show the YouTube. Lordship conversation with the Lordship. Lordship asked me certain question online.
Which is the order?
My name has not been included.
Here,
Lordship.
here.
I served notice to them.
How do you get?
I conversation.
Just a minute. How does it say virtually appear? What is your name has been omitted for respond number?
Conversation, Lordship,
No, sir. We are not going to rely on that. We rely on you. We are not going to admit that. We have taken your slip. We don't want to rely on that. Don't worry. We are not going to take evidence to substantiate a lawyer's version. You please, yes. The learned advocate, Mr. So-and-so.
My lord, I am the petitioner of this instant contempt application. AMT. So, my lord, I am the petitioner of this application and may kindly give me permission of lordship pass.
So what is pending? Tell us. What is pending?
Department did not pay me that's of salary. For this regard, my lord, I filed a contempt application.
You file a contempt.
Yes.
An MAT arises out of order passed in contempt.
Yes. Yes, my
The order is of which date? Impugned order is of which date? You don't have your file.
kindly issue a rule to call for the
Order is of which date? Order is of which date? The impugned order is of which date? Tell us which date order.
appeal कर किया कौन ऑर्डर कर ऑर्डर का डेट
Which order you are aggrieved by? Where is the order passed in the writ
Lordship, there
itself?
are three, he's challenged the three orders passed in contempt. That was dated 2019, Lordship, and various orders passed thereafter. But his actual grievance, Lordship, this is, I'm just putting it to your Lordship since he's appearing in person. He was given notional benefits. That he has not challenged that. Now he wants the pay. That
No,
is
so
what-
therefore we are saying there is a
Yes.
judgment passed by the court on 13th September 2019,
yes,
which he says has not been complied
that
with.
has been
Where is that order? Let us see.
Yes, Lordship.
Why you don't have your file, sir? Where is your file?
I filed contempt application MAT.
नहीं एमटी अपना मेमो रखी
A different bunch.
It's best to look into the memorandum of appeal because the application the memorandum of appeal one order dated 13th September 2019 that is challenged. Which 13th September 2019. Lordship, that order starts from
We have located it. Just let us.
আরো আছে order, আরো দুটো আছে এখানে। আরো একটা order।
কেননা কিন্তু পরে আমি দুটো অর্ডার ছিল, কেননা পরে যেগুলো আমরা পেয়েছিলাম এবং কন্টেন্টটাকে ডিসক্লোজার করবো এই দুটো।
Yes. So what remains? What is remaining?
Yes, my lord, I challenge the impugned order of premature retirement from service. In 31st August 1996, the department forcibly issued the premature retirement order. I challenge the impugned order of Honorable Supreme Court. The Honorable Justice S.P. Barocha and Honorable Justice B.N. Khere passed an order the petitioner entitled to file an application only for same relief. For this regard, your petitioner again filed an application of relief in 915 W of 1999.
Yes.
And after this matter, the appeal which was filed by Union of India, this appeal was pending. But before pending the appeal, they issue the premature retirement provision. Honorable Justice Satyaprat Sinha and Honorable Justice Devendu Bhushan Datta passed an order that the rule allowed and petitioner promoted the post according to seniority basis. My lord, till date, the department did not promote me and retire from service as a rank of head constable. My juniors already promoted as a rank of senior grade commandant, and they retired from service in 2007. My juniors. So I request a farm affidavit in court that according to seniority basis, department paid me the arrears for 71 lakh with interest, and petitioner entitled for fixed the rank of promotion, and already I expensed the rupees from 1972 to 2007, 25 lakh rupees, my lord, already I expensed. So the honorable court may decide this matter, and I am entitled for with cost in 25 lakh rupees.
After
1972 to 2025. So, your lordship, again, this is the sixth contempt application. May I kindly issue a rule and direct the Ajay Kumar Bhala, Secretary, Ministry of Home Affairs, Government of India, and Director General Thompson. They personally attend the court of time of the. My lord, I am old person, 82 or 83 years past away, my lord. So I request the honorable to may kindly decide this matter as your lordship found fit and proper.
After 915 of 99, did you file any writ petition?
Yes, my lord, already a farm affidavit in court. Already I have filed in previous day. And affidavit already I have filed. The department already filed and already reply of the same my lord. So I am entitled for 71 lakh with interest and voted at the rank of senior grade commandant according to seniority basis, and my lord 25 lakh rupees already I expend in court case on 53 years past by my lord. So my lord, I request may kindly consider this
After 915,
found fit and proper.
where is your lawyer? You had come with a lawyer one day. Where is he now?
I am person in Supreme Court or in High Court already.
But please, if you don't listen, if you can't, if you
So your lordship tell me that I engage in my, but already I augment lot of your lordship. May kindly pass an order to lordship found written.
After,
Whole person. So may kindly.
see, you are old person. You have said many times. We know you are old person. You are about 82, 83 years old. You have already said this. We are asking you whether after 915 you have filed any writ petition. After WP 915 of 99, what did you file any writ petition, or that was the last one?
No, so many applications already I have filed. May kindly see the record, my lord.
Again, we are asking you, after 915, did you file any writ petition?
Contempt applications already I.
We are asking you for the third time. After 915, did you file any writ petition?
Yes, I have.
Which writ petition after 915? Tell us. After 915, which writ petition you have filed? Tell us.
No, I didn't know any writ petition filed by lord.
Just now you said yes, now you are saying no. So after 915, you did not file any writ petition. 915 order, was it challenged?
Yes, my lord, I challenge and may kindly see.
915 you have challenged in which case number?
Case number.
The order passed in 915 of 99 has been challenged in which appeal? What is the appeal number?
Appeal number, my lord. 1806
Of
1000.
1806.
2024. And the contempt application disposed of by the Revenue Minister Chakraborty. For this regarding, I filed a MAT tender of amendments appeal in MAT. Council, your lordship, went to Supreme Court and Supreme Court passed an order, then petitioner entitled for leave granted and petitioner get the financial benefit.
See, you are not able to tell us what we want to know. How do we proceed in the matter? You are not able to tell us what we want to know. How do we proceed in the matter? We are asking you which appeal you have filed against order passed in WP 915. Where is the which appeal you have filed against WP 915? 1806 is not against 915. After 915, you have filed 5 contempt applications. 915 order, did you challenge in appeal? We are asking you for the 4th or 5th time. What did you challenge 915 order?
Lordship, could I just give seek leave to give a chronological list of days?
That will not, unless he is satisfied, that will not do.
Otherwise, it's very difficult.
He is unable to interact. We are asking him. He is repeatedly saying just 2 things. I am an aged person. I have gone to the Supreme Court. I have filed 5 contempt applications.
Lordship sees paragraph
On that basis,
9, paragraph 3. It doesn't appear that any appeal has been filed. It was a contempt application where the period of calculation there was a just to help the assist the court lordship whether we can just give a violation of the judgments, orders, appeals, everything. Parent order is the 19.
He apparently, from the order, it appears that it is being adjourned again and again, which is not a very good state of affairs. He is not able to assist us. He doesn't know. He cannot respond to our queries. What are we to do? We don't know. We are at a total loss.
There were defects.
Earlier, we asked him to get an advocate. He came with advocate. Now again, his advocate is gone.
Then the submission then was the defects have to be cured. What are the defects? I mean, then the appeal need to be cured, Lordship. That the learned advocate had submitted. Thereafter, he's not appearing either.
What remains to be paid to you? Tell us. किस ऑर्डर के खिलाफ आपने ये अपील दायर किया? किस ऑर्डर के खिलाफ आपने ये अपील दायर किया?
अपील फाइल किया कि डिपार्टमेंट डिड नॉट।
किस ऑर्डर के खिलाफ ये अपील आपने दायर किया है, बताइए।
अपील फाइल किया माय लॉर्ड आपको व्हेन द कंटेम्प्ट एप्लीकेशन डिस्पोज्ड ऑफ बाय ऑनरेबल जस्टिस तपोव्रता चक्रवर्ती फॉर दिस रिगार्ड अगेन आई फाइल ए MAT 1806
डिस्पोजल ऑफ कंटेम्प्ट, जिसमें कंटेम्प्ट में कोई पनिशमेंट नहीं हुआ, उसमें अपील फाइल हो सकती है डिवीजन बेंच में?
contempt already disposed by honorable court. For this regard again, if I file a MAT against the order of
उसमें क्या खराबी है? उस ऑर्डर में क्या त्रुटि है, बताइए। ऑर्डर दिखाइए, क्या उसमें गलती क्या है?
your petitioner challenge the impugn till date, my lord, this matter already quashing by honorable court. Premature retirement already quashing by honorable court. So I am entitled for all benefit.
आपको क्या मिलना है ये तो तय हो चुका ना रिट पिटिशन में।
कोर्ट में भी डिसाइड दिस मैटर।
अब कितनी बार डिसाइड होगा? रिट में तो तय कर दिया रिट कोर्ट ने कि आपको क्या मिलना है, तो अब कंटेम्प्ट में कैसे ये तय होगा? वो रिट का ऑर्डर आपने चैलेंज नहीं किया, आपसे हमने पूछा कि रिट का ऑर्डर आपने चैलेंज किया, आपने कहा नहीं। तो रिट में तो साफ साफ ऑर्डर जो है, पिछले बार आपने
सुप्रीम कोर्ट आई फाइल
वो तो खत्म हो गया ना, वो तो रिट खत्म हो गया, रिट का फैसला हो गया। तो रिट के फैसला में जो आपको मिला, उसके बाद आपने उसकी अपील नहीं दायर की, तो अब कंटेम्प्ट में क्या हो सकता है? इसमें कंटेम्प्ट में थोड़ी कुछ होगा। जो रिट का ऑर्डर है उसी का कंप्लायंस होना है ना। रिट का ऑर्डर कहाँ है, दिखाइए। 915 का ऑर्डर कहाँ है? 915 का ऑर्डर कहाँ है?
हाई कोर्ट में है।
ऑडिट का कोथा है, ऑडिट का देखना है कहाँ दिखाई ऑडिट।
ओ
हाँ
915 का।
हाँ
हाँ यस माय लॉर्ड।
हाँ हाँ लॉर्डशिप
Volume 6.
page 86 lordship that of him.
No, but that order seems to have been modified in contempt.
There was this order was not under challenge.
Can you give us the order seriatim
That is what I'm saying.
serial wise, right from 915?
1988, that is the best.
Not required. We'll
Not
proceed
required.
from 915. 915 is an order he has not challenged. But as we can gather from going through the last order, that 915 has subsequently been modified in a contempt jurisdiction. But he says 5 contempts were filed. So we
Lordship, I shall give a compilation of all whatever he has filed.
from 915 onwards, or you may give all the orders in a compilation.
Lordship, I think that will be, otherwise we can't.
In spite of repeated queries being made from the petitioner,
After number.
Number 6.
And acquired by the central government of Delay authorization dependence and pending before him. The ordering portion will
What is wrong? Why you are aggrieved by the order? Then go and file contempt. Why you have filed a writ petition? Yes, take down.
Yeah.
There is a direct.
The respondent.
But the petitioner is receiving family pension. In since the month of November 2004 to middle of 2015, the petitioner went to her native village and fell ill. As a result, she could not submit the life certificate. As a result of which, his family pension was stopped. After coming back in the year 2015, she prayed for family pension again. Then petitioner was asked to submit police report, and that was submitted. In spite of that, that was not paid to the petitioner. Thereafter, the petitioner filed an original application before the learned Central Administrative Tribunal, and during the pendency of the said tribunal, the amount was paid. Thereafter, the petitioner filed application for interest of the amount was lying with the authority concerned. The contention of the petitioner is that wrongly, rightly, the money was lying with the authority concerned.
Wrongly, rightly?
The money was lying with the authority concerned, but it has accrued some interest that we paid to the petitioner. That is the prayer of the petitioner.
After 2004, when did you approach them for the first time?
2015, my lord.
Where is that? Which document?
I filed application, my lord. I filed application before the authority. I filed application before the authority.
Where is that application?
Against that, an original application was moved, my lord.
You approached in 2015, and when have they paid?
My lord, page 16, my lord.
60.
16, 16, P2.
It was the bank letter.
Bank statement.
Bank statement. No. P2 is the bank letter of the bank.
Lord, page 17, my lord. 17, 17, my lord. P3.
When it was paid?
It was paid.
My lord, she is getting pension regularly, my lord.
Yes.
Only the claim or petitioner come before lordship for the interest part.
Yes, when it was paid.
Was paid, my lords. In the year 17 January 2019.
17 February,
17 January 2019.
17 January 2019. And this page 17 is the first letter that you wrote to them after 2004. You are for the railway or the bank? You are for the railway.
Yes.
So when she approached you in 2015,
Yes, she approached only in 2017, my lord, first time.
16. 16.
Page 17, my lord. Page 17, P3, my lord. 2016, sorry, my lord. 2016, 18 to 2016, my lord.
no,
After she is getting regularly pension, my lord,
please be
and
clear
what-
on facts. Please be clear on facts. She has approached in 2015.
my lord, document is
The
2016.
document is at page 16. You please see what the document says.
Page 16 is the letter addressed to the. No, it is the letter of the United Bank of India, my lord.
Yes.
Not legible paper, my lord.
And this was immediately sent to you also. It is marked to you. FA and CAO, Southeastern Railway. So don't say she has come in 17.
Yes, after the
She has come in 15. You knew that she has come in 15.
yes, copy to FNC, my lord.
Yes.
Standard bit.
So from 15 to 19, why it took you 4 years to start the pension?
But in this regard, we have to file opposition, my lord.
What opposition? You have not filed opposition in the tribunal.
No, I have not filed any opposition.
No. You think
My lord, there is the observation of the Central Administrative Tribunal, my lord, also, my lord.
No opposition was filed.
In this case, no opposition has been filed. This is the today.
Before the tribunal, did you file a reply?
My lord, before a time, lord. Tribunal consider here, my lord. This is observation of the last page, my lord.
Certificate is not
Paragraph 5, my lord. May I read, my lord?
You did not file reply in the tribunal. Was reply filed in the tribunal?
in their presence it was disposed of, my lord.
Huh?
The order was passed in their presence, my lord.
When we are asking you whether they have filed a reply, we did not ask you whether it was passed in their presence or passed behind their back. You are the applicant, therefore we are asking you. Take down.
He was also the applicant in
The petitioner
the time.
was a beneficiary of Where is the letter that they have written for restoring your pension?
There was there are 10 I have stated.
Nothing you have enclosed with DOA, with the writ petition.
Letter was at least
Yes, it was.
I have
That
stated.
letter was issued during pendency of your OA. The pension was paid to you. So what, yes, where is the document? First, you are not placing the reply on record. Nothing is there. You are just standing here. Why you file a writ petition like this without enclosing the relevant documents? You want us to understand something, or you just want to file for filing?
It was sent through bank and it
Huh?
was only from the bank I was informed and I received.
When your pension was started?
2019 while
They have said in the reply that they gave an instruction to the bank. Where is that instruction?
the bank will not to me.
Huh?
No instruction was given to me. Will a copy of that was not given.
So where is the order passed in the earlier way? Taking note of that communication.
Earlier way I have order annex. I have annexed the order.
Earlier order. Huh?
Annex the bank passbook also.
Where is the order passed in OA number 666 of 2017? Very unfortunate way of filing a writ petition. Where is the order passed in 666? You don't know anything yourself. Where is the
Page
question of placing it?
Page 34 I have annexed 1051. The order before
Page number 34 is the
34 is not 666.
1051. This one is 1051.
pendency of the 666 application, the payment was made by law.
That is what we are saying. So what has the tribunal recorded? It is pursuant to which order? Nothing is here. Now when we are asking you, then you are realizing that these facts are there. You just filed a writ petition. Give us interest. Give me the interest. That's all.
My prayer
Why
was
you file it like this without giving the documents? Why this has not been placed on record? In the reply also you have not annexed.
so page 36 later I was informed.
Paying for the filing my opposition ballot.
What opposition you will file? Here you go. The petitioner's family Give it back.
Item number 8.
For the petitioner, your lordship, the service isn't completed, so I'm praying for 2 days' time. The service isn't completed yet, your lordship.
Service is not required. We'll see whether service is required or not. If we find some merit, we will see. What is the order? Something like yes.
Shishana Bandyopadhyay is appearing for the state, but your lordship, he has not come to court.
Yes. Respondent is already appearing. Where is the question of service? Was any reply filed before the tribunal?
Lordship, give me 1 day time. I'll for not
You
to.
are appearing without a file. Why? You should come with the file. This is an opportunity for you. Why you are appearing without a file? That should not be done. That is not a correct way of appearing in court.
If it for not today, I'll come back tomorrow.
You have any instruction whether a reply was filed in the tribunal or not?
Your lordship, I don't have any instruction.
Both of you are only for seeking adjournment here. Why? It appears that reply. Yes.
For the statement.
You are appearing.
Yes, ma'am.
Any reply was filed before the tribunal?
No, ma'am.
How you can overlook a certificate issued by a competent authority? She has a disability certificate showing that she is 55% disabled. She competed and then you sent her for a regular medical examination prior to issuing the appointment letter. In that, some variance has come. On that basis, her disability certificate is to be ignored. A disability certificate is issued by a board which is constituted for that purpose. The subsequent medical examination is a routine. Everybody who gets an up before getting appointment letter, he has to go.
It was issued in the year 2014, my lord.
Before she became 18 years.
No, after.
Then, whenever it is issued, unless there is a duration for the certificate, it will continue for her life. Until such time that there is a finding that it is fraudulently obtained or it is wrong by an incompetent authority. District hospital has issued it.
Yes, ma'am.
They are competent under the rules and the advertisement. The issue arising for consideration.
I'm for the petitioner, Lordship.
Item number 9.
Lordship,
Yes.
due to your mistake, Lordship, we could not file the main application in the writ petition, Lordship. Lordship, paying for 1 week accommodation, Lordship, for filing supplementary affidavit, Lordship.
Why have you challenged the order? It is not, it is still pending before the tribunal.
Yes, Lordship.
Then why you have challenged the order? Why you have come here when it is still pending before the tribunal?
This matter is, Lordship, NOC and extraordinary leave, Lordship. Praying for extraordinary leave and NOC, Lordship.
So the tribunal will decide whether you have to get it or not. Why you have come here?
Tribunal.
Fixed on 24th July, my lord. I don't know the state of the matter which was taken up by the tribunal on 24th July. 24th
Yes.
July, the date still hoती. Second last page, my lord.
Yes. Why you have come to the High Court?
Class already comments, Lordship.
Huh?
Class already comments renewal.
So what? You go and join the class. Who is
Lordship.
stopping you? You seek interim order before the
Petitioners
tribunal.
not join the class, Lordship.
Why you have come here when it is pending before the tribunal? It may you have the grievance, therefore you have gone
Relief,
to that.
Lordship. Relief, Lordship. At least petitioner joined the class, Lordship.
Where is that relief? When have you prayed for before the tribunal for interim relief?
I already prayed, Lordship.
Where? Show us.
Kindly excuse me. To show the relief that was claimed
No, on 24th it was taken up. What happened on 24th?
on 21st.
Unnecessary, you are coming to the High Court when the matter is still pending.
On 24th, an order has been passed by which the state respondent sought for time.
All right.
In view of this time, the matter has again been deferred.
Maybe.
He wanted to bring it on record.
Not required, not required.
Sir, one mistake.
Nothing else is required, sir.
One mistake there has been.
Nothing else is required.
Application has been filed without, my lord, there is a reference of annexer, but inadvertently the copy of main application and
We are only asking you why, when the matter is pending before the tribunal, we have to take it up in a writ proceeding. Why?
because
Yes.
interim order which we prayed for at the time of having heard the matter
Yes.
is taken up for hearing.
So what is the urgency that
The
immediate?
urgency is-
Show us.
Yes.
Yes.
The urgency, tribunal application. The difficulty came on my part that tribunal application was not annexed. Therefore, my lord, I asked my learned advocate to obtain a copy of the tribunal application, and he has got a copy.
We are asking you a very simple question. What is the problem that if an order has not been passed, you have to come here, or order has to be passed? What is the circumstance? Tell us.
May I just my client has qualified in March NEET SS examination. Now
March 2025.
This year.
NEET SS. What is SS?
A medical all India exam, and he secured, my lord, he was successful because it's a course in throughout India, and rarely somebody qualifies in that. My client is an MD under the already existing MD under state of West Bengal. While he was as MD working and attached with state government,
Yes.
he qualified NEET SS. Now, my lord, in March 2025, upon he qualified NEET SS, he made an application before the state respondent for granting extraordinary leave. This extraordinary leave is there embedded in the service rule, which allows me to pursue, my lord, higher education, and I will not be getting a pay during this tenure. Now,
Yes.
after, my lord, was successful in NEET, I got provisional admission. The admission was with respondent number 7, that is Nil Ratan Sarkar Medical College. They admitted me provisionally, and a course of DM Neurology. This is a super specialty course.
We are asking you what is the urgency?
The urgency
Yes.
is that
We are not asking your entire academic qualification. What is your urgency?
1 minute I am coming, Miller. After I provisionally joined the respondent number 7, that is Nil Ratan Sarkar Medical College, they said that as the state government with whom I am attached now as Dr. MD, they said that you must bring a letter from the state respondent that you have been allowed extraordinary leave, or you can pursue this course in which you have already been admitted. To this effect, my client wrote me 3 representation that since I am attached with...
Where is the letter sent given to you by the Nil Ratan Sarkar?
These 3 letters were attached.
Not the 3 letter where they have asked you to give that
Yes, my lord.
permission or extraordinary leave. By which document?
Yes, my lord. Yes. I have also asked them 3টে আমাদের লেটার দাও যেটা আমি মার্ক করি। সঙ্গেটা লাগানো আছে। Kindly, my lord, give me 1 minute's time. হ্যাঁ 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 আছে, ওই অ্যাপ্লিকেশনটাই আছে, ওই অ্যাপ্লিকেশনটাই অ্যানেক্স করা আছে। হ্যাঁ সেইটাই একটা কপি আছে, বাট সেইটাই ফাইল করতে বলছিলাম। Milord, these have been annexed with the OA and supplementary affidavit. I have one copy. I wanted to bring it on record by filing a supplementary and giving him also a copy. For that, Milord, 2-3 days I time required to.
We are again asking you, you said the hospital asked you to get some permission. Where is that letter? Show us that the hospital asked you to get permission.
ডেটাটা দাও, স্টেটকে দিয়েছি, স্টেটকে নট allowed to join. Milord, may I just clarify? Your lordship's question is that only a letter from respondent number 7.
Your submission is
Mention this in this my.
no mention. We are not aware of any such requirement. Therefore, we are asking you. Once you join, you take extraordinary leave without pay, then how they will stop you?
No, the extraordinary leave.
So where is that requirement? Show us. Unless there is a requirement, where is the urgency?
না না আমি দেখছি কিন্তু possibly I can show it with after 5 minutes, no difficulty. I have wrote a letter.
Please show us the what they have asked you. Yes, we are coming back. You look for that document.
সাহেব আসছেন ততক্ষণ বের করতে। So prima facie, I must admit that the question which Lordship you are posing, that I must show something which has been written by respondent number 7, as I understand, my lord. But
You said that they have written to me. Therefore, we have asked you, where is it? You said that they asked me to come with a extraordinary leave or they will not allow me. So we said, where is it? Show us.
this we have specifically pleaded in our
Sorry.
application.
Then you go there. There is no urgency then. Sorry.
Just only a
Yes.
minute, my lord. My lord, kindly forgive me, my lord, for placing 2 minutes time, my lord. When I filed the application OA, I incorporated all this in pleading that after 3325, the college has given me provisionally admission. Twice, there are 3 letters which my client is also present.
Not required. You are here. We don't require your client. We don't want.
No, no.
Yes.
Your Lordship is absolute. My client wrote 3 letters to the government authorities. These 3 letters are part of the main application. Also, I have been placing.
Not required. We just want to see where they have asked you.
By-
That you have rushed here. Therefore, we are asking. Only on that issue. The tribunal will grant you all the relief. We don't know.
Your Lordship,
Maybe.
kindly grant me 2 minutes to explain this, my lord, that it is not at all material that whether they give me a letter or I give me a letter.
That is the material thing. Whether there is any urgency, that is all the material thing. Nothing else is material.
Allow me 1 or 2 minutes just to explain to your lordship. My lord, kindly, I bow down, my lord, your lordship. I will not be making much difficulty because when I plead it in my main application and seek for a relief based on the annexures which I have given to the respondent, and there is not a single statement or objection till now coming from them.
Then the tribunal may grant you the relief. That is precisely what we are saying.
But the difficulty which now I am facing.
Sorry, nothing, no urgency is made out.
Kindly consider my predicament.
We have considered.
My lord, 2 minutes, my lord. It's a, my lord, this, my lord, number of times the court have.
All right.
My
All
lord,
right.
well, kindly,
That's enough.
kindly allow me 2 minutes. Kindly allow me 2 minutes. Kindly.
2 plus 2, now 4 has gone. Now another 2 minutes. 6.
My lord, extremely, my lord.
Yes, another 2 minutes.
Kindly, my lord, consider that my client, my lord.
We are only on urgency. Why writ court directly? That is all.
I am coming to.
You are not giving one sheet of paper to make out urgency.
I am coming to the urgency.
Show us one sheet of paper.
My lord, my pleadings made in my application.
You are pleading that will not suffice.
Paragraphs from my pleading.
Yes, we have seen your pleading.
Been dealt with.
We have seen your pleading. It is there. Your representation is there. We have read it.
My lord, may I just kindly take your lordship to the representative?
No, we are not going to go into the OA. That is for the tribunal to consider.
Kindly consider. I know, my lord, this is for the tribunal.
Come to page 53. Come to page 53.
But why I have.
Come to page 53.
53 is the order, impugned order. Last one. My lord, may I just go through may I read the order itself? The matter is taken up by the single bench pursuant to order such and such on consent of learned counsel. This is, my lord, incorrectly recorded, my lord. There was no presence of other side advocate. I have explained this in my application. It was taken up ex parte for grant of interim order and admission. There was no presence of other side. That will be evident from the next order passed by the tribunal, that they have appeared on next date. The applicant has prayed for a direction upon the respondent authority to grant him NOC and extraordinary leave to undergo a course in DM neurology in Nil Ratan Sarkar Medical College. A detailed representation was furnished by the applicant before Director of Health Service on 27/5/2025. I will take your lordship to that representation, followed by reminders. These are part of the main application. From the representations, it appears that the applicant, who is a medical officer, was pursuing the course of DNB SS Cardiology at Rabindranath Tagore International Institute of Cardiac Science under study leave. My lord, I will pause. Kindly allow me to pause here. This petitioner previously, prior to in NEET SS, was admitted in DNS SS Cardiology at Rabindranath. That is prior to 33/25. The study leave was extended for 1 year and valid till 10/1/25. My lord, kindly take note of the date, my lord. This is prior to 33/25. As per the applicant, while pursuing this course, he suffered severe psychiatric illness and therefore could not complete the course. Having recovered and cleared NEET SS examination, the applicant has now prayed for NOC and extraordinary leave to pursue a different course, which is DM Neurology from Nil Ratan Sarkar Medical College and Hospital. The matter is admitted. Let the matter appear under hearing on 24th July, 25. A copy of this order to be communicated to the respondent number 3, Director of Health Service, Health and Family Welfare Department. Now, my lord, while this tribunal passed this order, my two representations and my inability to pursue the said course on the case pleaded and representation made for grant of interim order was not at all considered by the tribunal.
Show us where in your representation dated 27/5/25 you have said.
I'm grateful.
Show us, this is what grateful. This we have been asking you from the beginning. You are unnecessarily going into history, which is meaningless,
I'm extremely
which has nothing to do with today.
I am extremely sorry, my lord. I come to the representation itself. 27 কোন পেজে আছে? Page বলো না।
Come to 52. We have already told you. 52, sir, we are telling you. 49, 52, there are 2 page numbers. You decide which is the correct page number.
এই তো 27
Yes.
আছে। Page 49 I find.
Yes, where does it say that unless it is granted, I will not be able to pursue my... Show us.
May I read?
Yes, don't read the entire thing.
No.
Show us where it says. Yes.
Paragraph itself, my lord. I have understood what is falling.
Yes.
Despite, one paragraph itself.
Yes.
From the bottom 3rd paragraph I am reading, my lord. Despite my setbacks, I mustered the courage to appear once more for the NEET SS examination held on 30th March 25, hoping for a second chance to fulfill my aspirations. Since prior NOC was not required, for the appearing in the said course was not required, as per government order number such and such dated 2nd April 2024, I proceeded and appeared accordingly. I proceeded accordingly. By sheer perseverance, I secured an all India rank of 2370 in the examination. And based on my merit position, I have been allotted a DM Neurology seat at Nil Ratan Medical College and Hospital through the first round of NEET SS counseling for the academic session 2025 to 2028. This is 3 years course. In the light of such circumstances, I earnestly request your kind approval to grant me a NOC and extraordinary leave without pay to pursue this course. I humbly ask for one more opportunity to restore the course of my professional journey. Kindly stop my salary immediately and place me on extraordinary leave. I assure you that upon completing my DM course, I will dutifully resume my service and fulfill the necessary bound obligations. I had enclosed all necessary documents for your reference and kind consideration, and ever shall grateful for your benevolent support and guidelines in this matter. Together with this, may I just indicate, my lord, a 5 years that after I complete the course, I will be serving them 5 years, a bond is required to be given, that we have also given to the authority concerned. And the second representation, which was a part of that, is also the next page, page 50. The same thing is being repeated here also. My lord, may I kindly excuse me for repeating the same another representation. Despite my setback, I mustered the courage to appear once more in NEET SS examination, which was held on 30th March 25, hoping for a second chance to fulfill my aspiration. Since prior NOC was not required as per such and such circular, I proceeded accordingly. By sheer perseverance, I secured an all India rank of 2370 in the examination, and based on my merit, I have been allowed a DM neurology seat at Nil Ratan Sarkar Medical College and Hospital through the first round of NEET SS counseling for the academic session 2025-2028. In the light of these circumstances, I earnestly request your kind approval to grant me a NOC and extraordinary leave without pay to pursue the course. I humbly ask one more opportunity to restore the course of my professional journey. Kindly stop my salary immediately and place me on extraordinary leave. I assure you that upon completing my DM course, I will be dutifully resume my service to the fulfill necessary bond obligations. My lord, pausing here for a moment. After these representations, my salary was also in terms of this ledger stopped. Therefore, I am not getting any salary and I am not in work also. But the difficulty cropped in my part that though a part of the relief I prayed for in these two representations have been given to me, the salary was stopped. But the NOC which I sought for to continue is being withheld, and there has been no response from these two respondents with respect to these successive representations.
That's all.
Because they are, because, my lord, acceding to this, I'm extremely sorry for the difficulty, my lord, if any. Acceding to these representations, the authority, my lord, stopped my salary, and the next page is my additional. Page 51 is the provisional admission letter of Nil Ratan Sarkar Medical College Hospital. Therefore, on this, I have been, and there are only 2 seats in NRS Medical College. These seats cannot be filled up by any candidate excepting me. But the difficulty which I, my lord, now I am facing, that part of the relief, that salary though was stopped by these 2 representations, but no response was received by the respondent authority, that is Director of Health Service, and my lord, in the consequent next letter relating to that, I have been allowed to pursue the course or join or grant of provisional NOC. This is creating an impediment on my part so as to join it.
That is not apparent from your
My lord,
representation. That is not apparent from your representation. There is no requirement that unless you do it, you cannot start. We have not found it from the, you are saying so, but it is not borne from the record.
My lord, this subject.
Sorry, it is not there.
My lord, kindly.
Yes.
I bow down.
And in March, you have competed, you have waited till May, and now we are in August.
No. In April, I approached before.
That's what we are saying. Maybe you, whatever it is to be done is to be done by the tribunal. We are not going to exercise jurisdiction in this.
After making these 2 representations on 26.
Where is the admission order? Your admission order.
4th July.
Where is it?
4th July, this is the admission order. This is the first order.
Sir, where is the admission granted to you for the course?
Oh, I'm sorry. Page 51. Page 50.
Page 51 is the counseling.
Page 51, provisional admission letter. Admission letter.
What is the date?
Page 51, your lordship will find. This is my lord admission letter. Page 51. Kindly look to the top. NEET SS Counseling 2024 provisional admission letter. Application. Father's name your lordship will find. Thereafter your lordship will find
The date.
Nil Ratan Sarkar, the name of the hospital where he has been admitted. In the middle, Nil Ratan Sarkar Medical College Hospital. And this is the, my lord, letter of issued by NRS Medical College, Kolkata. Professor, your lordship will find. There is no dispute with regard to this, my lord. I do not know my learned senior friend is appearing for respondent number 7 or not. My lord, to this extent there is no dispute. I do not know whether my learned friend is appearing for respondent number 7 or not. if he is appearing for respondent number 7, your lordship may kindly, this is the, I have been told he is appearing. Now, my lord, page 51 is the letter issued by respondent number 7. And it inevitably, there are only 2 posts available in NRS Medical College.
How many times you will say that, sir?
I'm sorry. I am sorry.
How many times you will say that?
Still sorry, my lord, for repeating. I bowed out.
2 posts are there and I can only join, nobody else can join. How many times you will say this? Yes.
I must not repeat everything.
Yeah.
I must not repeat everything. But
That's all.
But
That's enough. Yes, sorry. Take down.
One
No,
minute,
enough is enough.
I will not go much. These 2 representations and
We are not going to interfere, sir. We have already said. Enough is enough. Please. Please. Please.
My lord, it's not
No, it's enough.
allowing me.
We have already gone through everything.
The tribunal allowed me.
We have gone through everything.
Your lordship. Your lordship will be passed.
You think this will help you by doing this? Repeating the same thing 3 times, 4 times is going to help you. You really think so? Everybody is waiting for their case and you are repeating the same thing 4 times. You think that will help you?
I will not take more than 1 minute.
No, 2 minutes, 2 minutes. You have been saying you have already taken 20 minutes.
Kindly allow me to just.
For a matter which is pending before the tribunal.
It's pending, but
and nothing urgency has been shown.
My lord, the urgency.
Sorry.
My lord, may I just say the urgency has been
Take down.
needed in the supplementary affidavit. But
So,
the difficulty they
you
will
are-
never do it.
you are
my
the
case
party.
will become infructuous.
You are not appearing means what? So you tell whoever is appearing, yes?
Kindly one
We are
line,
the learned advocate for the petitioner submits.
kindly explain.
Item 10, Malat, though I am ready with the read petition, but I missed one judgment. But if you let's say, can you only one document, tomorrow I shall come with that judgment only, Malat.
But I am appearing on behalf of Public Service Commission.
Recruitment for the post of Assistant Director in Agriculture. Malat, they have violated the settled law. Malat, first of all, in terms of the settled law, the authorities shall publish the list after the screening test according to the merits. But here, in spite of securing much marks under OBC category than the general category candidate, they were placed under the OBC category without placing them in the general category. That is one aspect. And secondly, they have called in the interview test, in spite of very minimum candidates, they called in the interview test only 1:2 ratio.
Why not 1:4?
Yes, that's my prayer.
Why not 1:5?
At least the Supreme Court have considered this.
So please tell us why 1:3 instead of 1:2?
At least that's it. That
Why at least? Why not more?
Yes, that may be more, but
Why not 1:10?
The Supreme Court have specifically held.
Is such a prayer is maintainable?
Yes, that issue has been decided by the
No, no, no.
That judgment,
Sorry.
bring it tomorrow, kindly.
Not required. Let us see where is the advertisement.
Yes, page 20.
You have not even qualified the preliminary.
Yes, I have qualified in the preliminary. I have qualified in the preliminary.
Then means you have been excluded.
No, after preliminary, straightway interview. Nothing else.
One preliminary test
Yes.
and interview.
Thereafter interview.
Where is the advertisement?
Yes, page 24.
Page
24, my lord.
You are under which category?
OBC A category, madam.
Yeah.
12 vacancies there, not OBC A category. without considering our merit, matlab they have eliminated matlab.
Yes.
Matlab kindly see matlab once.
Yes.
Now matlab page 32 is the matlab admit card of the first petitioner.
Yes.
Matlab she was selected matlab page 34, kindly see page 34.
Yes.
She was selected after the screening test matlab 1770.
Why you are showing? Who is disputing that?
Yes, matlab. Now matlab kindly see the.
So you want that the cutoff should be increased.
Yes, matlab.
That is a unique prayer. For the first
Matlab,
time we are seeing.
Page 47, matlab, kindly see.
Yes.
Page 47. What is the cutoff?
Because you are below cutoff mark, therefore cutoff should be increased.
Cutoff mark has been fixed, matlab, kindly.
No. With that we are not required to see. That the writ court is not required to see.
Page 47 once, matlab, kindly.
Show us your OA. Where is your OA? Come to your OA.
Kindly, I am coming to the OA. I have annexed the into OA, matlab. Page 47. What is the cutoff marks fixed for general category and OBC A category? Kindly see, matlab. Unreserved category, lordship got page 47, matlab. Kindly see once, matlab, page 47. Unreserved category cutoff marks is 66.75. And the OBC A category 65.75. Now, matlab, kindly see the list. Matlab, page 62. Kindly see the ones, page 62. So kindly see page 62 once, madam. Page 62 once, matlab, kindly see. Before the interview, they have published the list. Where they have published the score of the individual candidates. At least 20 candidates of OBC category is there. Kindly see page 62.
What is the, what was the date of interview?
Date of interview perhaps was 24th January to 19th February.
And when this was published?
This was published on 10th of January.
So in between 10th and 24th, what did you do?
I approached the tribunal, Malat.
Between 10th and 24th?
Perhaps Malat, I approached before that, Malat.
Before 10th?
Malat, I am coming, Malat. The date of affirmation is there, Malat, I am coming.
Because on 10th, they have notified that we will be calling 1:2. What did you do for 14 days?
On 11th February, Malat, I filed this matter before the tribunal.
Even after interview?
No.
Yes, even after interview. Don't say no, just.
Yes, ma'am.
Don't have to retort everything that the court says. Please think of it before you say yes.
Malat, kindly see the page 62 once. Malat, kindly see the page 62 once, Malat.
Yes, show us whatever you want to show us.
This is the list of qualified candidates for interview. After the screening test, there was no test. They simply published the candidates who are called for interview. There are 20 candidates under OBC categories there. who secured much marks than the cutoff marks in general category. As per the settled law, they will come as a general category candidate, not as
Okay.
OBC candidate. This is the judgment. I have two judgments to that effect. The Supreme Court as well as the judgment delivered by the Punjab and Haryana High Court. Kindly see this judgment. But the court categorically held, first they have to publish the merit list, irrespective of the fact whoever is.
You did not challenge this list. You never challenged. That's why we are asking you. On 10th January, they have published this. You did nothing. Interview was also done. After everything is over, then in February, you file an OA and then you say that all this is wrong. That is why we asked you. What did you do? You did nothing. And so therefore, everybody cannot be made to suffer because you are inactive and you are procrastinating and not approaching the court or the authority within time. Then everybody cannot be made to suffer. Did you even make any objection to anyone between 10 to 14, 24? Nothing. All those who have participated, they cannot be made to suffer because you take your own time, you sleep over your rights, therefore everybody should suffer.
Their action is absolutely contrary to settled law.
We don't know whether you have approached or not. Forget about that. First, tell us your conduct has to be seen. This is a public employment.
I prayed for a revision of the list. They have
Much after the interview was over. What can be done?
On 11th, I filed it.
11th February, 24th January was the interview.
No, interview was on 9th February, up to 9th February.
Up to 9th, still after that you have done it. Why you are waiting? Nobody knows. When you are already out on 10th January, you know that you are not in the process.
That is fact.
Then what can be done?
But their action is absolutely
We don't know. We don't know. We don't know. From this list, we cannot see that the general is below the OBC. We cannot see. We are unable to appreciate. Yes, show us from that list. We are giving you one more opportunity.
Page 62, my lord.
Yes.
Page 62, my lord. Kindly see serial number 134.
Yes.
His score is 68.25.
Yes.
Under OBC A category.
Yes.
But the cutoff marks in the general category is 66.75.
From where do we get this?
Yes, my lord. That is on my lord, page that I have page 47.
Page 47.
They fix the cutoff marks unreserved category 66.75. 66.75.
All right. So
will automatically come as a general category.
So how do we know that he has not been considered as a general category?
Because this list has been published for interview.
This list has been published, yes, but whether he has been considered as unreserved or not, how do you know?
But his list.
He is no. You have not even made him a party. Nothing you have done.
How many candidates I cannot, I do not know how many candidates they have.
You do. The entire list is before you. You are relying on the list.
No, address is there, I cannot collect the address,
Anyway, that is something else.
Allow me to add them,
Not at this stage. Not anymore.
One candidate, only 20 candidates.
Sorry.
Can you see the entire list? 20 candidates.
What is this list?
Of marks is mass than the general category, so they will automatically come as a general category.
They must have been. They must have been. They must have been considered as unreserved. Where have you said in your OA? Show us from the OA where you have said that though they have got more marks than general, they have been considered as OBC. Show us that averment in your OA. Just by looking at a list, such submission cannot be made. They are shown marks against their category. They may have been considered as unreserved. We don't know. That fact, unless it is there in the OA, how you can say it? You cannot say it. No such a statement has been made by you in the OA. Obviously, you know that this is not the correct position. Otherwise, you would have said so. Your only claim is that it should be 1:3, not 1:2. Nothing else in the OA. You can only make your submission based on the factual foundation in the OA, not anything else. And even if it is 1:3, we don't know whether you will come through or not. Nobody knows because everything will change.
Only 25 candidates they have called for the interview. Only 25.
That's all then.
That was 256 candidate qualified.
All right.
They have
Yes,
50
take down.
candidates.
Third learned advocate for the applicant.
My lord, I'm appearing for the petitioner, my lord. I'm praying for short passover, my lord. As the learned advocate on record is engaging in court number 2. If your lordship kindly fix at 2 p.m., my lord, she will come back and address your lordship.
What is the rule governing this benefit? Can you please show us the rule governing this benefit? Yeah. Yes, sir. What was the illness being suffered? Just tell us what is the illness.
Yes, my lord. The fact of the case is that, my lord, whenever the petitioner went to the for his medical treatment or medical checkup, my lord, outside the state, which is also the hospital, which is also under the scheme of the West Bengal health rules, my lord. And while he was checking up or dealing with the checkup, my lord, he was suddenly got a heart attack, and that is why, my lord, he was suddenly advised to undergo the surgery, and that is the entire fact of the case. And thereafter, my lord, when the petitioner claimed before the concerned authority to reimburse the claim, my lord, his claim was rejected due to the fact or the ground that he could not.
Prior approval was not
Yes.
taken. So therefore, we are asking you, let us see the
Yes,
rule.
my lord, it is there, my lord. I am not properly prepared, my lord. If your lordship kindly fix it on 2 p.m., my lord, the learned advocate on record will address your lordship and satisfy your lordship. It is there, my lord. I am late.
That scheme is page 58, but subsequently that is amended, my lord, amended scheme, my lord, that is page 75.
(14/8, 2018).
Yes. And my lord, amendment scheme is page 75. I am covered by these, my lord, scheme, page 75 scheme.
So how is this relevant?
My lord, this is as per existing norms, government employees, pensioners. My lord, I am the pensioner.
No, they are only saying that you have got the treatment without prior approval.
Yes.
That is the only thing.
Only issue. My lord, here kindly see, are required to submit their reimbursement claim for both OPD and indoor treatment. My lord, my treatment is indoor treatment. I went to the Chennai hospital for my routine checkup, and at that moment, the doctor discovered that I am a 100% my lord heart blockage. Immediate referred to admit the hospital, and operation is being made immediately. And I have no scope to take prior approval or prior my lord intimation.
So how this is relevant? That is why we are.
This is indoor treatment. And
This is only regarding claim delay in claim reimbursement. This is not about prior approval. This has nothing to do with prior approval. So how this will apply? Therefore, we are.
After treatment within 3 months.
After treatment comes later. First, there is a requirement of prior permission. Where is that prior permission?
There is no scope at all, because
Where is that provision? This is not applicable. Where is that provision? Show us which requires prior approval. This is not relevant to your claim. They are not saying that you have submitted claim belatedly. That is not the case.
I am covered by the pension holders.
Where is that requirement of prior approval? Show us.
That is scheme I annex page 58, 7A, page 58, and subsequently
58.
58 and 59. They are showing 7.1 and 7.2, 7.1 and 7.2, 7.1, clause 7.1 and 7.2. The entire cost of the treatment, there is no specific averment that prior permission have to be taken by the.
This is a notification of 23.
Yes.
No, where is the guideline, madam?
collected from page 58 from the website.
No, this is not the guideline.
They are not showing these that contents that prior approval have to be taken.
This is not the guideline. This is a notification. This is a clarification regarding OPD treatment. This is not the guideline. Where is the guideline?
Scheme, my lord, I have to show, my lord, before your lordship, my lord, entire scheme I annexed by way of supplementary affidavit. Because scheme, my lord, entire scheme that is showing before in the tribunal, my lord, they did not show any, my lord, scheme. No scheme has been shown. Only, my lord,
You are coming for relief. You have to show. They are not required to show.
I have annexed page 58.
58 is not the scheme. 58 is not relevant to your claim. We have already seen. What they are objecting is that you did not have prior approval. We understand what you are saying, that emergent situation, how can we have a prior approval? But where is the requirement? First, we want to see where is the requirement. Is it a strict requirement that a patient, whether he survives or not, he should not get? Can it be to that extent? Therefore, we want to see.
I annexed before the tribunal. My lord, entire scheme.
And what is the bill amount?
My lord, bill amount 4 lakh something.
Where is the bill?
My lord, my discharge, I annexed. With my representation also.
What is RAF? Rapid Action Force. Rapid Action Force. Take down. The petitioner applicant, a retired deputy commandant of the
12,
But I am in item number 14. Well, it is probably analogous. 12, 13, 14, 15.
To 15. What is the application for? You are not appearing in 12.
Will be small at WPST 26623 of 2002. You don't have word?
What is the order impugned?
But I have come before your lordship for restoration of the contempt application, which I have filed, my lord, in the year of 2016.
In all these cases, there is a restoration.
Only I have filed the restoration application in connection with WPST 623 of 2002 and CPN 519 of
23. Which serial, which item number?
Item number 14.
14. So your restoration is number, can number 1.
CPN, Malad, I am seeking Malad, for filing restoration of can number 1. Malad.
14. Huh? So can is filed. Can 1 is you have jointly filed with another petitioner.
I have filed the restoration application in respect of CPN 519 of 2006.
Correct. So that is the first case. That's not 14. PSC number 623. Six 23 is same. What is the difference between 12 and 14? We don't find any difference. Both are in CPN 519 arising out of 623.
Well,
both are, so there were more than one party in that case.
Yes, yes. In the initial malad, the WPST, there is more than one.
And in CPN?
The CPN also more than one.
CPN also?
More than one.
So
I am the petitioners in CPN malad, applicant number 8. In the contempt application, I am the single person, malad. Ashutosh Midda.
Contempt means CPN 519.
5-1.
But can has been filed in item 12 also regarding CPN 519. So how you are saying you are the only person?
But in the contempt application, malad, kindly see malad CPN 519.
Yes, there are 8 petitioners in contempt. How you are saying you are single?
But I have filed the contempt application, malad, singly.
There are 8 petitioners in
8
5.
petitioners. Thereafter, page 5, my lord, kindly have a look.
Page 5 of
Applicant is one, Ashutosh Smith. Page 5 of the contempt application. my lord.
C will come back. Just wait, we'll come back. We'll take it up after.
Item number 4.
Not for passing orders. Yes. No, you had placed the pension regulations for Air Force. Which provision?
So pension regulation 11 and judgments are not carrying my brief. So tomorrow I'll do.
No, we don't remember because I had gone through this morning. The last order is that you will be placing reliance on this pension regulation. After that,
Respondent had said that they will be handing over copy of those regulations to your lordships.
now it is there. But then which provision is being relied upon? That is what we are. The facts are very clear. There are 3 conditions: CAD and diabetes, and one that compression or fracture which he has sustained while ejecting from the aircraft.
That's not part
So he is saying that has not been considered, and plus CAD also has not been considered because you say he was a chain smoker. But which provision you are relying upon, that I think it was to be pointed out.
8. Lordship, let it appear tomorrow.
Already. Not today.
I'll also inform my other side.
Please, not today.
Item number 110.
This is not under for orders. None appears for the writ petitioner.
Confusion is there. My lord, I have the review order and appeared. Read the review order.
The review order. You are appearing in which matter? 100? WPCT 315.
This is judgment delivered by your lord.
No, it was not. It was reserved. Thereafter, we were informed that whether this order was passed by a single administrative member, that issue is pending in review. Therefore, we did not pass the order. Now review has been decided.
My lord, I don't know anything.
No, we were informed.
Administrative member can pass the order.
Now it is the judgment review order has already said that yes, single judge can decide the issue.
Yes, ma'am.
Yes.
So tribunal is singly.
So now we have to consider it. We had not passed the judgment. Last day you were not here when it was taken up. On 25/7.
Pass any judgment, lordship, deliver it. I have already argued in this matter. my lord.
No, 25/7 you were here or you were not here. Then We had heard the matter, you are correct, but immediately thereafter we were informed that review is pending. Therefore, we didn't pass it. Now the review has been decided, so now you will have to refresh on one day. Only then we can proceed. Whenever you want. Today, tomorrow, after 1 week, 2 weeks, whenever.
Any Friday, a fixed date on
At 2 p.m.
Next week, next week,
We'll keep it on 22nd. It's a Friday.
Yes,
All
my
right.
lord, at 2 p.m., my lord, it will be
List under the
Item number 12 to 15. Okay.
The CPN 519 was disposed on merits.
In respect, my lord, of my CPN 519, my lord, that has not been, my lord, disposed of, my lord, subject to correction, my lord.
Not been disposed of.
That's why, my lord, it was dismissed for default. My lord, that's why I filed the restoration application. My lord, I have annexed the orders of my restoration application CAN 1.
Dismissed for default on which date?
In the 29th January 2016 itself.
16.
So there is a delay, my lord. I have taken out an application for condonation of delay also, CAN 2.
How many days delay?
3,451 days.
Only. But the other CPN, it was listed along with the other cases. Although CPN has been decided on merit on 6/1/2005. You are also claiming that marks of the written has not been added. That was your case. That was a common case of all the candidates. The High Court held that 40% will be the minimum qualifying, and whoever qualifies, their number you add, and as per availability of vacancy, they should be offered the appointment. Now,
another thing is that, my lord, I have not been included in the SC candidate.
but that was never an issue. How it can become an issue in contempt? You have never raised this issue in the writ petition.
Respect of contempt application, my lord, that can be restored.
No, why after 9.5 years it should be restored? That is what we are asking. Nearly 10 years. Why? What have you said in CAN?
But acting advocate, my lord, do not. If the transfer be of me, my lord.
Yes.
My lord, contempt application, my lord,
You have see what you have said in paragraph 4 and 5 of CAN. Please read. For 9 years you were sleeping and then you have approached your lawyer. And on this ground it should be condoned. How it can be? Have you served a copy of the CAN application?
nobody was appearing in the contempt application, my lord. Without order of this honorable court, I cannot serve it, my lord.
You are appearing in 14. So nobody is appearing in 20, 12, 13 and 15.
Fine.
You are not appearing in 15.
I am the only person, my lord, who has been left out. My lord.
None
Who have been
appears on behalf of the petitioner stroke applicants.
May I have humble submission for Can 4 of 2025 to my lordship in person. My application is for cancellation of. Oh, sorry.
Take down. An application has been filed on the
Last occasion, your lordship directed to police the rules.
We can consider if you give like that.
Original yes, but Xerox copy is also there.
So give us Xerox copies. Where is the judgment of Prabhavati? 96(7) SCC. Yes.
After
right after putting 6 months service or obtaining the status of a temporary workman. The appointment to a temporary post after screening is entitled to family pension. This is after Pohabati, my lord. Your lordship kindly sees.
Somebody is appearing for the other side. Already some lawyer is appearing from before. Yes.
Whichever is appearing, those are the respondents.
Where is he?
He's on leg at court number 16, my lord.
So what do you have to say?
Pray for 1 day accommodation.
Why you are coming so late, sir?
I'm sorry, my lord. It's fine. I beg apology, my lord.
Really sorry, my lord. Kindly pardon. Sir.
The learned advocate for the applicant petition, for the petitioner. Please.
Item number 18.
Have you enclosed the way? With the page?
Starts at page 17, my lord. This is the index. 16 it starts, my lord. P1.
What they have asked you to submit?
Taxation certificate.
Why are you shy of submitting that?
Certificate because I am a class 2 here. And there is an, admittedly, there is an existing class 1 here.
So did you implement the class 1 here?
Very brief, my lord. My instruction is that he has been impleted, my lord. And I have served the CAN applications that I have filed, my lord. To effect service, I have given a copy of these CAN applications to the added respondent, my lord. Point number 8, subject to correction.
You have given a service report.
Yes, no, my lord. Yeah. Respondent number 5, my lord. I stand correct.
Who is appearing for the others?
Mrs. Kakoli Samajpati was appearing for the state respondents, but I am told, my lord, now, my lord, Abhishek Prasad has been engaged in this matter, my lord, subject to correction, my lord. The last I could recollect, my lord.
And can is pending, can 1.
And can 2 both are pending, my lord. Can 1 is for restoration, my lord, because it was dismissed for default by an order dated 13th of June 2023, my lord.
So you have served the can application. Ask the state council to be here. According who you are, you said who is to appear for the state?
My lord, Mr. Abhishek Prasad, my lord.
There is none to represent the state respondents. 1 affidavit.
My lord, in item number 19, I beg to appear for the respondents. My
Item
lord.
number 19 to 21.
My lord, in item number 19, I beg to appear for the respondents. My lord, at the outset, I tender my apology, heartfelt apologies, my lord, because I am constrained to appear online today.
Yes, you are welcome.
Deeply obliged, my lord.
I am appearing for the petitioners. Yes, writ petitions were dismissed, Your Lordship, in 2019, after which review application was filed and it was assigned before the division bench, and the writ petition was restored, Your Lordship, on the observations that the submissions made before the Honorable Division Bench by the respondents during the hearing of these applications were erroneous. This pertains to the selection process of semi-skilled tradesmen by OF Damdam, Ordnance Factory Damdam, Your Lordship. The petitioners were selected and were in the merit list. I would like to refer to WPCT 2, Your Lordship, because WPCT, the applicant of WPCT 2 had filed the review.
So we are taking up a review.
Review is disposed of, Your Lordship, but the observations and the order passed in review application will assist in deciding this writ application.
So after review, another writ.
No, this writ application was pending since 2019, Your Lordship, against the order passed by the Honorable Central Administrative Tribunal. This was heard and dismissed by Honorable Justice Dipankar Datta and Shogato Bhattacharya. Later on, I had filed a review application which was assigned to Honorable Justice Sharaf and Honorable Justice Shogato Bhattacharya. This review application was disposed in March 2024, Your Lordship. And this writ, the order which was, the dismissal order was revoked and this was restored. This
So review was allowed.
Yes, Your Lordship.
Where is the order allowing the review?
It is in the record of the review application.
What is the date? What is the date of the order? Just tell us.
2nd March 2023, Your Lordship. 2nd March 2023. রিভিউয়ের ফাইলটা আছে?
Yes.
Your Lordship, this petitioners were semi-skilled craftsmen, Your Lordship. And they were
Craftsmen.
semi-skilled tradesmen.
Tradesmen.
Yes. And on 2 occasions, they were selected by the Ordnance Factory Board for the same post. Both the petitioners, once for Pune Ordnance Factory and another second time for Dam Ordnance Factory. It was a mistake on the part of the petitioner that he did not join the services in Pune and preferred this appointment in OF Dam since he was he resided in Odisha. Now, Your Lordship.
So he participated in a process twice.
Twice, Your Lordship. Twice he had participated. Once before the Pune Ordnance Factory Board.
There he had emerged successful.
Yes.
He did not join.
He did not join. Second time before the Dam factory on the same in the same year, Your Lordship. He secured the position.
The 2 recruitment process were separate.
Separate, but post was same, and it was conducted by Ordnance Factory Board, centralized recruitment process. Now, Your Lordship, after the entire selection process was concluded, attestation form was issued. He was awaiting his appointment letter. He came to know that the entire process has been kept in abeyance through RTI applications and appeal, whatever.
So nobody was appointed.
Yes, nobody was appointed. Now, Your Lordship, he made a representation before the Ordnance Factory Board. It was also not replied. Then he found another recruitment process of the same post has been circulated by the Ordnance Factory Board.
So that means they have aborted the earlier process.
No, they have not cancelled the panel. They have not informed anything. It was
what informed? If the same posts are notified against, that means it is already over.
These 27 posts were exclusively for this reserved category, Your Lordship. Only for the reserved category.
The one in which you participated.
Yes.
It was only for reserved category.
Yes, OBC.
So the subsequent included more.
So
therefore,
145 candidates were there.
That means the earlier process is aborted. Yes.
No, Your Lordship, it was not abandoned. During the course of the application before the Honorable Tribunal, retest was also conducted. A number of procedures were followed up, Your Lordship. Retest of 27 vacancies. And the subsequent vacancy was of 145, Your Lordship, in which he
145, and prior to that?
Yes.
And the one prior to that, it was for how many vacancies? 27. 27 reserved only.
Yes, reserved. In which he
so
qualified.
27 was was a process based on which advertisement?
Advertisement dated 10th September 2010, Your Lordship.
And this subsequent one, 145?
It was in 2011, Your Lordship, in November.
Can you give us the date?
Yes, Your Lordship. 7th November 2011, Your Lordship. It is.
So your case is that this second one is a totally different.
Not different, Your Lordship, because these posts were included.
That's what we said, but you said no. It must have been included.
Yeah, it is.
So once it is included, that means that the earlier process is over.
It is not said that it is.
May not be. Yes.
But he applied for the subsequent advertisement also.
2010 one.
2010 as well as 11. 10 he obtained third position.
Yes.
11 he submitted his application along with 50 rupees draft and everything.
Yes.
But while the hearing was
he was not issued any admit card.
He was not issued. That a protection was given to him since the finality of the decision of the Honorable Tribunal, Your Lordship.
The tribunal, what was the matter pending before the tribunal?
That 27.
27, that's
Yes.
why they are not proceeding further.
Yes, Your Lordship. Because there was no objection regarding their performance or anything, but due to some anomalies, the entire process was kept in abeyance. So the prayer was that they should be considered prior to the initiation of a fresh recruitment process of 145, which included few posts of this semi-skilled tradesmen. Now, Your Lordship, they did not appear for a long time, even if Dasti was issued. Later on, they filed a reply and conducted retest, against which he filed a miscellaneous application that let this matter be decided first. Then the fresh retest may be conducted. But they conducted on that ground that result of the retest is yet to be published, this writ petition was dismissed by the Honorable CAT, and interim protection was also vacated. Now, Your Lordship, during the hearing before the
What is the OA number of 2010?
636, Your Lordship.
636 of
2013.
13.
Yes, Your Lordship. It was filed in 13.
So that the tribunal took note of the fact that it has become infructuous.
Not infructuous, because his right was protected after a miscellaneous application was filed. The Honorable Tribunal directed him to participate in the retest without prejudice to the contentions of the applications. So after he appeared in the retest in November 2014, Your Lordship, 30th November 2014, the vigilance report was brought before the Honorable High Court. It was gone through, and Your Lordship, during the hearing, it was contended that since he has participated in the retest and the result is yet to be published, this it may be dismissed by the respondent said that we have conducted retest, and on that ground, Your Lordship, it was dismissed.
When?
And no direction was issued to the respondent.
When?
It was in 2018, Your Lordship, March 2018. It's 27th March 2018, Your Lordship.
Yes.
Thereafter, Your Lordship, I had filed these writ applications before the Honorable High Court.
Against the dismissal.
Against the dismissal, because the contentions which were made by the respondent were not.
But you seem to have said that you did not participate in the retest.
No, I participated in the retest, Your Lordship, but they contended that the result is yet to be published. It is premature to say anything about the retest, and on that context, this writ petition was hearing was concluded, Your Lordship. It is in page 124 onwards, Your Lordship.
So the retest result was not declared.
Not declared, Your Lordship. Before the Honorable High Court, they made the submission that result has been declared and he has been found unsuccessful.
So what is the position today?
It was not declared, Your Lordship.
Never declared till now.
Retest was also not declared, but now they contended before the review bench that he secured 62nd position. So, Your Lordship, that's why he is not qualified. But since the entire process has been cancelled, how they can take this plea that he has not obtained or secured the secured position?
No, that means the result must have been published. Otherwise, how would they know that you are 62?
Yes, Your Lordship. They have not published the result, and they have uploaded in the website that the entire process could not be carried on for some other irregularities, Your Lordship. In review application, they have filed all this in affidavits, Your Lordship. Objections and affidavits were filed on behalf of the respondent, and a number of contradictions were there. In the vigilance, they have cited that on 3 dates, the examinations were conducted, but from the records, from my client's records, it is found that all disciplines were, all fitters, mechanics, and other disciplinary subjects were tested on the same day, Your Lordship, 7th of March. Now, Your Lordship, he is affected first by not issuing the appointment letter, secondly by not giving him an opportunity to appear in the selection process of 145 vacancies, third by not publishing the result of the retest, Your Lordship, and being a qualified person, twice he has been selected and he has secured good marks in both the examinations, both the candidates, writ petition number 1 and 2.
No, but the order which has been reviewed
Yes.
is 9/8/2019.
Yes, Your Lordship. Order was passed in 2023.
Yeah, no, 9/8/2019.
It is the order passed by the Honorable Tribunal, Your Lordship.
No, it's the order passed by the Honorable Division Bench.
Yes, it is the order
It was
passed.
by Honorable Justice Dipankar Datta.
Yes, Your Lordship. Yes, yes, yes. August.
We don't
Yes.
find that it takes note of any fact that the result has been declared.
Yes, Your Lordship may kindly see the order. It is mentioned that he could not succeed. He could not succeed in the examination.
Failed to succeed.
He has not succeeded in the examination. Your Lordship, it is in the order is in CAN 1554 in the review application, Your Lordship. I may be allowed to read out, Your Lordship. The unsuccessful applicant of OA 1146 2013 decided by Central Administrative Tribunal by its judgment and order dated 27th March 2018. The petitioner is before us. The case pleaded in the original application of the petitioner.
Yes, come to page 2, last sentence. True it is.
Page 2. It is not in dispute.
True it is the petitioner appeared in the retest but on the basis of liberty granted by the tribunal and failed to succeed.
Yes, this is a wrong submission made, Your Lordship.
This is not a submission, this is the court's finding.
This is a submission of the respondent, Your Lordship. On the submission of the respondent,
No, it is a fact being taken note of by the court which is not in dispute.
it is in dispute, Your Lordship. In the subsequent proceeding before the review.
In review, you have
Yes, yes, Your Lordship. They produced the documents and it was shown that they had never published this retest results, Your Lordship. And
So now what is the
and-
relief that you can claim?
Your Lordship, since I have been given the interim protection for being successful in the first examination, Your Lordship, of 27 vacancies.
Where is that order?
Yes, Your Lordship. The order is in page, Your Lordship, page 44.
Of?
44 of the WPCT 2 of 2018, Your Lordship.
Page 42.
57, Your Lordship may kindly see page 57. The detailed order is in page 57. The applicant is aggrieved by the fact that although he is found successful in the written examination trade test held on 7/3/21, 2011 in connection with the direct recruitment in the semi-skilled grade and has been selected for the post of fitter in March 2011, but he has not been granted appointment. After filing of RTI application, he has come
Page
to
57.
57 of the WPCT 2 of 2018, Your Lordship.
Tribunal's order.
Yes, Your Lordship.
Yes.
Order. The applicant is aggrieved by the fact that although he is found successful in the written examination trade test held on 7/3/2011 in connection with the direct recruitment in the semi-skilled grade and has been selected for the post of fitter in March 2011, but he has not been granted appointment. After filing of RTI application, he has come to know that the selection process has been kept in abeyance by the department. The respondents have re-advertised the post in the month of November 2012. He is aggrieved that if the posts are filled up, he would not be considered despite being declared successful. We feel that a reply is necessary in the matter to ascertain the position with regard to the earlier selection trade test held on 7/3/2011 and its outcome. Although the prayer has been made for seeking interim protection to stay of the said notification of 2012 November, it can be considered after reply is filed by the department. Now, Your Lordship, Dasti was issued, which is in page 46, Your Lordship. Page 46, the order of interim protection is there, Your Lordship. On On 11/7/2013, we indicated that respondent shall file reply upon filing reply, the prayer seeking interim protection of stay of the said notification of November 2012 can be considered. The learned counsel for the applicant submits that if the posts are filled up, he would not be considered despite being declared successful in an earlier examination. No reply has been filed till date. We direct authorities to file reply within 4 weeks. With regard to grant of interim protection, we direct the appointment to one post in subsequent notification of 2012. In future, mechanic shall abide by the result of this application.
No, but that is over now. The OA was dismissed.
Yes, Your Lordship.
So once the OA is dismissed, where is the interim order?
The interim order is no longer there, Your
Therefore, it
Lordship.
is now.
But since it is not there, Your Lordship, he is suffering. Only 138 posts have been
What do you mean suffering? After that interim order, the OA has finally been decided.
finally been decided, but in review, the order has been set aside, Your Lordship.
Not the tribunal's order.
No, tribunal's order will be set aside by
Tribunal's
Your
order is
Lordship.
already, it is now a long time, since about now 12 years that interim order has
No.
remained.
From 2013 to 2018, the interim order continued, Your Lordship.
How?
Because the proceedings were there before the Honorable Tribunal. They delayed the proceedings.
Tribunal proceedings ended when?
2018.
Still,
5
for the
years.
last 7 years, it is over.
It is over, Your Lordship, but before.
There is no interim order for the last 7 years.
But vacancy is there, Your Lordship. I had
Maybe.
paid before the Honorable Division Bench.
Therefore, we ask you, according to you, what is the relief that you will get today?
Lordship, I should get the appointment because I have been deprived.
Appointment in relation to a process which was never completed.
Retest was conducted. Whatever formalities they had to undertake, they
How
took.
do you know that you are eligible for appointment?
I
You are,
was-
if you make this claim, there must be a basis.
I was selected, Your Lordship. I
Were selected, but it was found that the procedure was suffering from some kind of malaise. So it was not acted upon, never acted upon for anyone. So
Yes,
how
Your
can an exception be created for you?
Lordship, in the second recruitment process, I had submitted my application. I was denied opportunity to participate in the recruitment process.
That's not before us. That is not the issue before us now.
That is not before Your Lordship, but that aspect came before the Honorable Court, for which it was dismissed, Your Lordship.
Maybe we are asking you how any relief can be granted with relation to the first proceeding.
Your Lordship, a selection process of reserved category cannot be kept in abeyance throughout.
We don't know for the last so many years where those vacancies have gone, subsequently whether any recruitment process.
They had replied. They had the replies in affidavit that 138 posts have been filled up.
Because to that extent, the order of this division bench, which has been reviewed.
Yes, Your Lordship. The Honorable, the Apex Court.
That is, this court has taken note. Yes.
Lordship, the Honorable Apex Court, Honorable Justice Dipankar Datta in Supreme Court had decided. Your Lordship, one The actions were malified, your lordship. The actions of the respondents, they delayed the entire proceeding.
See, the division bench has not, the division bench, although now it has been reviewed, but the division bench has not dismissed because you did not succeed. That's not the ground.
Two grounds were there, your lordship. One, that I had not applied for the second recruitment process. It is also mentioned in the order passed by the Honorable.
Whatever may be, see what
These two grounds.
what ultimately the division bench says is, however, side cannot be lost of the settled position that whenever a process is perceived by recruiting authority to be conceived in fraud and delivered in deceit, an individual innocence has no place and the entire selection has to be set aside. Precisely what your case is,
Lordship, it has
that
been
it
set
is an
aside.
individual innocence.
Yes, your
So
lordship.
this is not because you did not succeed or anything. It says, however,
But
all things aside, this is the settled legal position.
Lordship, I am a qualified unemployed person. My case before the tribunal was filed in 2013. This could have been concluded in 14 or 15, your lordship.
That doesn't help you.
No, they made
That doesn't help you.
They made the proposal of retest, your lordship.
They may have. How does that improve the situation that the proceeding was vitiated on account of fraud, deceit, and all kinds of mischief being played in the recruitment process? That does not change. They may have done a subsequent, they may not have. That is already, if there is a finding.
On the base.
And that finding is not dependent upon your success or failure in the subsequent process. It says, however, after taking note of everything. So that is a finding which is independent of all the other things.
Yes, your lordship. But my right I have been deprived of my rights, your lordship. This judgment of Honorable Justice Dipankar Datta in the Supreme Court, your lordship, can cast a light on which I am referring, your lordship. A person cannot be deprived of his rights for inordinate period when the respondents have not acted in accordance.
Where is the right? Once the procedure is aborted, where is the right?
Lordship,
Right is gone.
No, this appointment was given after 25 years, your lordship.
Maybe it can be given after 50 years, maybe we don't know, but provided the process is is still alive, here there is a conscious decision that it has not been acted upon. Without acting upon it, they have issued a subsequent advertisement. You applied in the subsequent also. You say the High Court took note of the fact that I have applied, but I have not succeeded, therefore reject. That's not the case. The case is the High Court took note of the fact that the entire process was vitiated, and the settled law is that it has to be cancelled, and an individual innocence does not have anything.
Your lordship,
Has no value in such a procedure.
No, the procedure of 27 selection was not was vitiated, but they had conducted retest, your lordship. That retest was also never declared. The result of that retest was not declared because that too was vitiated.
Where is the review order passed in review?
It is these are the copies, your lordship. Sorry. Rejected. আরেকটা এই যে Your lordship, before the review, at the time of hearing, they had Your lordship, I may be allowed to show the orders before the Honorable Tribunal, which ultimately culminated to the dismissal, because throughout the proceedings, they had always delayed. They have not filed the replies. They have delayed the vigilance report. And before the review bench, they had even agreed to accommodate his appointment, your lordship. These judgments may be referred, your lordship, to judgments of Honorable Justice Dipankar. Your Lordship, page 11, paragraph 15 is relevant, Your Lordship. Your Lordship,
For difference between this judgment and the judgment?
difference is there, Your Lordship, but the state
It
should
makes
act.
all the difference.
No.
What act? Once the process is over, it is over. Where is the question of any? Here he was found successful. His name figured in the merit list, and then thereafter they were raising a claim of some equivalence of his educational qualification. So the court said, consider it.
Your Lordship,
Here the entire process, there is no dispute that the process has never been acted upon for anyone.
but
It's not in
retest-
dispute.
Your Lordship, retest was conducted.
It is over.
So it should not be the whims of the authority to declare it or not to declare it. A reserved post has to be accommodated sooner or later, Your Lordship. This is the direction given by the Lordship. May kindly consider, because both the petitioners are now reeling under.
Yes, what do you have to say?
মিউট হয়ে রয়েছে।
My lord, I apologize. My lord, initially, my lord, there was an advertisement for 27 tradesmen, appointment of 27 tradesmen. Thereafter, my lord, 145 as regards the advertisement regarding 145 tradesmen, that did not include the 27 tradesmen. Now, before the Honorable Tribunal, my lord, it was my learned friend client's contention, specific prayer, that he be given appointment letter with regard to the advertisement relating to 27 tradesmen. Until he is not given the appointment letter, nobody should be appointed from the 145 post, for the 145 posts advertisement. Now, my lord, interim protection was given to him, that as regards 145 posts, one post should be kept vacant, so that if he succeeds, he can be accommodated. Now, thereafter, my lord, we found vigilance, they found that there were severe anomalies, severe malices in the selection process. That is why that was entirely 27 tradesmen, that was entirely scrapped. Now, my lord, with regard to 145, my lord,
Where is the decision scrapping that recruitment process?
My lord, it was made part of the Honorable Tribunal's order. It was placed before the Honorable Tribunal.
Let
and
us see.
Reasons, my lord, and the reasons, my lord, were also cited over there. My Lord, the Honorable Tribunal's final order judgment is it is the last connection to the WPCT, my Lord, from internal. It is the last connection, my Lord. It's
Where is your reply filed before the tribunal? Let us see what
reply is
your
also there, my Lord. I place it before your Lordship. Supplementary affidavit was also made, my Lord. It is at page 85. Page 85, my Lord, of the WPCT, my Lord. And at page 96, my Lord, we have enumerated the irregularities in the process of recruitment. My Lord, at page 96 of WPCT. If your Lordship allows me, may I read, my Lord? Page 96. My Lord, kindly see point C.
page 90?
96, my Lord. 96, my Lord. 96 of the WPCT. Irregularities in the process of recruitment. And in fact, the records were placed, I believe my learned friend will not deny, the records were placed, my Lord, before the Honorable Tribunal.
But by a pseudonymous person, your Lordship, as far as I recollect. Page 98, your Lordship, some.
From 96. And whether these 27 posts were included in the subsequent process or not.
No, my lord. No, my lord. It was not included. It was absolutely a separate advertisement, separate selection process, my lord.
No, separate selection process is correct, but
these 27 were not included, my lord.
from where do we get this fact? Because it appears you are at item, both of you, on this aspect that 27 posts was not included in the second process.
27. My lord, the advertisement possibly. In this regard, my lord, the advertisement for 145 posts possibly will assist your lordship. My lord, kindly bear with me.
Yes, look, have a look.
It's at page 38 onwards. Yes, it's at page 38 on. No, I apologize, my lord. It's at page 42 onwards, my lord.
This is the
It's
second.
very small.
This is the second
one.
advertisement.
Second advertisement, my lord.
42 onwards.
42 onwards.
Why you say onwards? There's just a one page advertisement.
One page, my lord. I apologize.
38 is the.
No, 38.
38, page number 38 is the advertisement for the subsequent 145.
This is the one.
Yes.
And what is 42?
38 to page 40. 42 is for 27 vacancies, your lordship.
The earlier one.
No, it is the newspaper advertisement and these are the website advertisements of the same.
Both are one and the same.
145 advertisements. 38 onwards. And here vacancies of fitter are there.
These included, my lord, for recruitment of workmen in semi-skilled grade for Ordnance Factory Dong Dong. This is one advertisement and another advertisement for Ordnance Factory Nalanda. Both were conducted by Ordnance Factory Board, my lord.
Yes, this is the subsequent one because the earlier one is of 2010.
My lord.
But this is of 2012.
That advertisement is also there, your lordship.
But you said 7/11/2011.
12, your lordship. It will be 2012. And the first advertisement is also there, your lordship.
So when was the decision taken to scrap the earlier process? Is there any material to show what is the date on which you decided that the earlier process is not to be?
During the pendency of the proceedings before the CAT, my lord, probably, but we had.
So much after issuance of the second advertisement. That is why perhaps it was not included in the second advertisement. Because by then there was no decision as to what is to be done with regard to this.
27.
So the orders of Honorable CAT, wherein a direction was given to the respondents to file reply. If they fail, the right will be forfeited and at the cost of ₹500. After that, they came and before the Honorable Court and said that retest will be conducted and the matter will be. Now, your lordship, one contradiction is there regarding the issues which were raised for cancelling this selection process as referred by my learned friend at page 98, your lordship.
Yes.
Paragraph 3, written test of the vitiated recruitment process was conducted in 3 phases on 3 days. That is on 7/3/4/4 and this, recalling this ratio and the relevant trade of all diploma holders to fill up the post of examiners. Your lordship may kindly see 121 of my application, your lordship, wherein from 121 to 123, I have annexed 3 admit cards of 3 different trades whose examination was conducted on 7/3/2011, your lordship, which is contradicting their statements.
We are not going to look into these disputed issues of fact. This is not the only ground. The entire process is vitiated. The ratio is not correct. The manner in which interview has been conducted is not correct. The questions have been sent twice and thrice to these authorities. It appears that it was rightly cancelled.
Yes.
15 minutes to 4 minutes interview, everything is, just see the report.
Responsibly.
There's a host of, lot of irregularities,
But-
illegality.
But this.
In fact, senior officials have also been proceeded against
Yes, Your Lordship.
for
but-
doing this.
Yes, Your Lord. But
Therefore, you cannot derive any benefit from such a
Your
process.
Lordship, repeated arbitrariness cannot be accepted, Your Lordship, because
What arbitrariness? How can you be a beneficiary of such an exercise?
no retest should have been conducted in.
That is over. That is over.
I have suffered at the end of the
Now
day.
the issue is whether you are to get anything out of the first exercise or not. That is the only issue.
No, since I have been denied an opportunity to
The
appear in the 45.
interim order only protected your right to raise this issue. That is why you are here. Otherwise, you cannot be here.
Your Lordship, the subsequent advertisement included 29.
It did not. It did not.
Yes, Your Lordship.
The subsequent advertisement was much prior to the disclosure of the facts in the supplementary
But
affidavit.
identical posts were advertised, Your Lordship.
May be identical, and those posts are two different things.
But I was denied.
Your post was kept vacant pursuant to your orders. How your post could have been advertised? It could not have been. You have already got an interim order that your post is not to be filled up. So therefore, your post was not advertised.
I was not given. Now, Your Lordship, this entire process has been scrapped. I was denied opportunity to appear in the examination of 145 candidates, Your Lordship.
Very good. So. Please dictate the order in court itself and pass the order in court on. Keep it under the heading for orders. List under the heading for orders on 25th, Monday.
Item number 22.
My lord, in 22, my lord, I appear for the petitioner, my lord. But before I move this matter, my lord, I must be candid before my lord and admit that my restoration application is on board today, my lord. But upon going through the file, my lord, I could not trace the affidavit of service, my lord. It was served, my lord. It was a 2023 matter. But if my lord kindly allows me, my lord, I can come back next week, my lord. I shall serve the principal respondents with Geological Survey of India, my lord, fresh and file a fresh affidavit of service to that effect, my lord. That is, my lord, the difficulty, my lord, today.
Let notice of the application be served and affidavit of service filed.
Twenty-three.
Lordship, I'm led by Mr. Vishwarup Bhattacharya. He is on his leg from courtroom number 13. Ashwa appearing for the petitioner. I'm being led by Mr. Vishwarup Bhattacharya, Lordship. এটা দাদার দিকটা? Lordship, this matter was এই একটু তো আগে তুই ছিলিস। এটা তো কত ভাই এপ্লাইটা কি ফাইল করেছিল?
The disciplinary proceeding has not concluded.
Lordship, now it has been concluded, Your Lordship. Lordship, what has happened, Your Lordship, at the stage of charge sheet, we had filed the application. Now the matter was heard, Your Lordship, before it could be heard out by this honorable court. We were under challenging the charge sheet and the initial proceedings because, Your Lordship, what is happening here, the allegations are such, Your Lordship, in pursuant to which they are saying certain the accounts and there are funds which are beyond the scope of an government employee. Now, what is happening, Your Lordship? Now, with pertaining to this, they have already initiated a CBI inquiry and a charge sheet has been given and the criminal proceedings are now pending. Now, Your Lordship, our first stand, which we wanted to place before the Honorable Court was that during the pendency of the criminal proceedings, when it is arising out of the same charges, can I disclose my evidence before the disciplinary authority or before the court of the criminal proceeding? That was our first question. Nothing was certain. In the meantime, they had passed an order whereby
You have claimed quashing of the charge memo. This is not your case.
Lordship, we have that point of
Your prayer is for quashing of the charge memo.
Lordship,
Yes, that's not your prayer that it should not proceed during pendency of a criminal case.
It is there in the petition.
Let us see from the OA.
Lordship, may I humbly pray, Your Lordship, I am being led by my senior Lordship. He is engaged in court 13. Lordship, may I pray for a short passover? This matter needs to be argued by him, Your Lordship. There are several points which needs to be placed.
You have challenged that charge memo only. The charge memo has been challenged and now you admit that the final order has been passed.
Now the final order has been passed pending adjudication of this writ petition.
Maybe. So now that is required to be challenged.
Whatever is falling from Your Lordship, may I humbly pray for a short passover or maybe only not today, not today, Your Lordship. It's extremely urgent. I also want to move the matter.
Where is the charge memo? Let us see.
Lordship.
It's 388. Order under challenge. Yes, I understand, my lord. Inquiry report 217, my lord.
We asked where is the charge memo?
Where is the charge sheet?
Charge sheet হচ্ছে পেজটা কত জন আছে?
300, whatever you said, that is the OA.
120 is also annexed in 120, my lord. And 118, my lord.
And where is this is the OA at page 30. So OA number 572 of 22. What is the OA number?
Number is 572 of 2020.
And which page you said the charge memo is at which page?
The 118.
118.
Statement of article is 121.
And where is the inquiry report of 29 July 23?
Inquiry report of 17th.
Inquiry report is 217, my lord.
17. 7-1.
17.
17 is the
17.
inquiry report.
218.
217 is the memorandum. 218.
18.
Yes, this is the covering letter.
Lordship 218.
Where is the conclusion? Which page?
Page 252, my lord.
52.
252.
So charge memo is of 2019. An inquiry report submitted in 23.
It was continuing, my lord.
Huh?
It was continuing, my lord.
Obviously.
I mean, what is his reply? If you lordships kindly see, he has only replied to the charges that the bank cannot disclose this kind of.
Just wait. Let them. What is this option I've been given? So after the disciplinary authority passed the order, what happened? Some punishment has been inflicted.
Now the punishment has been given only in the month of July, against which I had preferred an application wherein I was praying for a stay in the meantime. However, your lordship directed that let the matter be heard finally. This is the order. Now, in the meantime, when the writ petition was also pending, this order was passed, which I have annexed in Can 1. It is of 15 January 2025. Upon the recommendation of the UPSC, this order was passed.
So did you file any, make a representation against the inquiry report?
Lordship.
Did you make a representation against the inquiry report?
Lordship. At that stage, I had made it.
Where is that? So you have participated in the inquiry throughout.
Lordship. Not throughout, your lordship. At the initial stage, I have participated in the inquiry, your lordship. The inquiry proceeding in the manner which is conducted, that is under challenge. Lordship, I am being led by Mr. Bhattacharya.
Yes. No, we were going slow so that you come. We were informed about it. So therefore we were proceeding slowly, that if in the meantime you will come. Yes. So you have challenged the charge memo after submission of an inquiry report.
that is, according to me, legally not permissible. I should have come to the court at the threshold. If your lordship asked me legally as an officer of court, my lord, I should assist your lordship by placing the correct petition below.
And this is a fact which cannot be changed.
Actually, my lord, here your lordship is looking at a charge sheet, which is an offshoot of some CBI recommendation. And my lord, criminal case in respect of which the charges are yet to be framed, but it is the same set of allegations that have been leveled against me. Now, my lord, that criminal case, my lord, and disciplinary proceedings side by side, my lord, together on the self-same allegations, perhaps, my lord, was not maintainable. Though, my lord, the law has diluted today to the extent that it cannot be blanketly stayed.
GM tank and all these judgments are there.
Have now not been diluted to hold, the today's view, of the honorable.
Both can proceed.
Both can proceed. Disclosure of defense is one issue which would perhaps, be an issue for your lordship's very gracious consideration. Captain Paul Anthony was.
M. Paul Anthony, yes, that is why we are saying subsequently GM tank and all these judgments have come.
Now the thing is, the law today has flowed to this extent that as a matter of course, a disciplinary proceeding cannot be stayed.
Point is,
Now
the issue is you cannot be prejudiced by disclosing your defense in a departmental proceeding during pendency of a criminal trial on the same charges, on the same set of evidence. But you were not prejudiced because you never assailed anything. After the inquiry was over, you have come. Therefore, we asked you.
That is the only,
So therefore, in this circumstance, now that the disciplinary authority has passed the order, you are to go in appeal. That is the only remedy available.
One is, I have to assail the
That
final
ground you could have taken if you had come after the charge memo that please stay the proceedings. It's the same charges, same set of evidence. But that is, you have come after inquiry report, after everything is over. So that point is not available to you. And once the inquiry report is submitted and a representation opportunity is given to you, you must have availed of the opportunity.
They have not, they have.
Come to page 217. Come to page 217.
Yes, your lordship is correct. Now what has happened is, if my lords kindly take the copy of the application, which I have taken out. Just,
yes.
One thing it's my duty to point out, at interim stage, when the matter, did not go to this extent, there was an order, that any order or any steps taken would abide by the result of the petition. Though that is a very usual order, it goes nowhere.
It still will abide by the result. Who is saying it will not abide by the result?
But legally speaking, since there is a final order.
Now a disciplinary authority's order, how can we look into it? You know the.
I cannot even, as an.
In fact, in fact,
I can argue it. But as an officer of court, I cannot argue.
In fact, it is.
Which was not under challenge.
It is all the more better because the latitude which an appellate authority will have, we will not have in these proceedings.
Just give me 1 second. Instruction. It keeps it day after tomorrow, I'll come.
Yes. After some arguments, Mr. Swenswell. All.
24.
I appear under the petitioner.
For petitioner. Huh? This is still pending.
Still pending. Here the one notification giving the pendency of the application for notification was published. The special circumstances promotion was given which is not participant. And court passed an order fixing the date in the month of December.
So why you are here? Go before the tribunal.
Because the tribunal, the tribunal is the crisis of the judge, and whether the only one member is functioning and that member is going to stay coming back. I will not take it.
But this order you are challenging of January 24, December 23.
No. Challenge.
Yes, sir. September 23.
No, I have not. I filed an application for interim order.
What interim order? Order September 23 order is being challenged. In 25, your matter is being taken up after 2 years. This can one. Why you file an application for preponing the date? Who is stopping you? Why the High Court has to prepone the date of a tribunal?
Tribunal down to one point, one judge is functioning. Then coming back. There is no bail at all. In case that
Unnecessary, it is pending here for no purpose.
Lordship, I have instruction from the state. It says that state doesn't have any problem if Lordship refers back, directs the tribunal single judge to hear the matter.
They have never moved. They could have filed an application that let it be taken. Then that direction is only for expediting.
157 by the same judge, London judge expressing inability for taking up the matter being a single matter.
Where is that order?
Yes. Page on the application page 57.
He is not expressing any difficulty. You could have made an application, let it be taken up by a single bench. Why you are not? If you don't want to keep it pending, then it will remain pending. That is what we are looking at. He has not expressed any disappointment. Yes. So you can ask him that you please consider it singly. Why you have not asked him? Everybody knows that in this courtroom. Therefore, we are asking you what prevented you from asking him to consider it as a single judge. Why? You have never asked him. You are just allowing him to give one adjournment after the other, just keeping this matter pending here. Futile exercise. You are not in a hurry. You just want this to be pending.
Pick up the matter, hereafter change the mind. If you also send you have to.
We know. Still, you could have made an application.
39, if you also send.
Yes. Who is stopping you for moving, for placing it before a single bench? You could have done that.
Page 39, your lordship can have.
That is what we are saying. Who is stopping you? If this is not the original order is much earlier. That is why we said.
Took up the matter, fix up the date of hearing.
Now you see the order dated 11/9/23. The single bench did not fix up the matter. So since then you are doing nothing. Since then you have done nothing that it should be taken up by a single bench. This is just being followed in all the subsequent orders. You just want to keep the matter pending, obviously.
This is the problem that facing
That is a problem created by you.
But the learned tribunal before that.
You could have asked him.
The problem, I gave you lordship. Lordship knows that it is a lordship here. Now the tribunal will be, the judge is coming.
We don't know when that happens, what will happen. We don't know. You go and pray for listing before a single bench. You file an application, it will be considered. He is saying the affidavit and all is filed.
They are not filing.
But I don't have any instruction at present. Director, I will ask the department to file the.
You are doing nothing, sir. Why they will file an affidavit? Every order you are taking to the High Court. This is what you are doing. You are doing nothing there. Yes, every order. Just see your application. Each and every order annexing in the High Court. As if we are the tribunal.
When our account page 53, the lordships kindly have a look. The order passed by
Nothing.
giving promotion, which is not.
We don't know. We are not going to enter the merits directly unless the tribunal has decided the issue. We are not.
May come back day after tomorrow.
Tomorrow.
Day after tomorrow, your lordship.
I can find out who is appearing from this side and my junior file is not. One day will be late.